Please welcome the President and CEO of Alliance Defending Freedom, Michael Farris.
Good morning. My name is Mike Farris. I'm the President and CEO of Alliance Defending Freedom International. ADF International is a faith-based legal organization that protects fundamental freedoms and promotes the inherent dignity of all people. We've seen all over the world how important it is to make sure that the victims of persecution get their day in court so that they can protect their right to religious freedom, whether that's in Asia, the Middle East, Africa, Latin America, or Europe. Government needs to be held responsible when it violates this most fundamental right. Now, it's my pleasure to introduce and moderate this panel where we're going to look at all different ways that top legal minds around the world are protecting religious freedom in courts. First on the panel is Tehmina Arora. Tehmina is my dear friend and is the Director of Advocacy Asia for ADF International. She works closely with allied attorneys. She and her team have achieved several critical victories in various courts across the region, including the successful challenge to an Indian law requiring religious converts to register with the state, seeking compensation for victims of communal and targeted violence, reopening places of worship that were shut down arbitrarily, and successfully defending religious minorities wrongfully accused under blasphemy laws and anti-conversion laws. Tehmina, it's been my pleasure to be with you in India on a couple of occasions, just very recently. Can you tell our audience more about these anti-conversion laws and what it's been like challenging them?
Yeah, thank you very much, Mike. It's truly an honor to be here. I was told to hold up this mic like Whitney Houston, so that's what I'm going to try and do. 10 provinces in India have enacted what are euphemistically called Freedom of Religion Acts. They are really anti-conversion laws, and several other provinces have these laws in the pipeline. These laws require that every time there's a religious conversion, you have to inform the local authorities and seek their permission before you can convert. The previous laws required intimation, but now it's permission. These laws fail to recognize that conversion is a process of the heart, of the mind. It is not something that is done to me, it is something that I'm choosing for myself. I decide what I believe. I think about Christians in the eastern part of India that have waited for months on end to receive permission from local authorities before they can convert. These are poor communities, but are rich in their faith, in their inner voice, in their inner life, and yet they're being told that they must wait till the government decides that it is okay for them to convert. The newer laws also incentivize violence against religious minorities by providing incentives, financial incentives, if you report religious conversions. This leads to mobs terrorizing people. These laws have also been used to target interfaith marriages, especially Hindu-Muslim marriages. People are harassed, arrested, simply for marrying outside their faith tradition. Penal provisions under the laws range from 1 year to 10 years imprisonment, including fines. And they have shifted the burden of proof on the accused. So if you accuse me of forcibly converting you, I have to now prove that I'm innocent. This is a complete change in criminal jurisprudence. I give you the case of Ramchand, a young pastor who was invited to a Christian home, a brother's home, to pray. As he got there, a mob showed up. The mob attacked him, beat him up, and he was taken to the police by the mob. The police then choose to arrest him. They take no action against the mob. We litigated this case for several years before he was finally acquitted of his crime. The punishment is in the process. There is, in fact, no known case of conversion, forcible conversion, in India. The laws have been on our books since 1967, since 68, and yet not one known case of conviction under the laws. However, they lead to increased violence against the community. We run, along with several others, a hotline where people can call in to report violence, often as it's happening in real time, and the phone is ringing off the hook. Last year, we had over 500 incidents where Christians were targeted for their faith. And the police chose to file first information reports only in 10%, 47 criminal complaints, 500 attacks. The same police that is eager to arrest, eager to detain Christian pastors when they are accused by mobs, choose to take no action when the mobs have beaten up the pastors. The possession of rights is meaningless unless there is a redressal method. And also, religious conversion is the test case for religious freedom. I really hope that through our interactions here, our states will take increased action to protect the most fundamental of freedoms for all people. Thank you, Mike.
Thank you, Tehmina. Next is Steve Perles. Steve is the founder of the Perles Law Firm, a firm specializing in private litigation against state sponsors of terrorism, which have included Iran, Syria, Sudan, and Libya. Additionally, his firm brings lawsuits against large financial institutions that launder money for terrorist organizations. Steve's 40-plus year career, he started when he was 9, has resulted in reparations for thousands of American victims of terrorism and their family members. He's an adjunct professor at William & Mary Law School, a trustee of the Boston Symphony Orchestra, and has 2 children and 2 grandchildren. Steve, could you tell us what Lawfare is and give us a brief overview of the anti-terrorism litigation and how that can serve as a model for fighting for religious freedom?
Well, thank you very much. I was rather surprised and flattered to be invited to today's events, as I don't work in the, generally I don't work in the religious freedom space. We're really in what's called Lawfare, or the counterterrorism civil space. Many people think, or it's commonly thought, that the counterterrorism civil space is about creating compensation for victims of terrorism. All of our clients are either United States nationals or non-US nationals who are killed or injured in terrorist attacks as a result of their service to the United States. Those people are principally State Department employees who are at the wrong end of an embassy, for example, when a bomb is detonated. But it is a misnomer to think of it as compensation. It's really about deterrence. What we try to do, whether we're engaged in litigation against a foreign sovereign or banks that are moving money, either for sovereigns or private actors, to people who murder citizens of this country, is to make that event phenomenally expensive. And you know, our math is a matter of public record. We've taken something between $3.5 and $4 billion away from material supporters of terrorist attacks and redistributed that money back to their U.S. national and non-U.S. national U.S. government employee victims. We like to think that that has had a significant deterrent effect. You know, we did a lot of litigation against Muammar Gaddafi's Libya for the bombing campaign that he ran against the United States. And when it was over and we were no longer in litigation, the Libyan foreign minister, he's a professional diplomat, if you would, and we had dinner together, and you know, it was interesting to hear him speak without admitting that they had ever engaged in a bombing campaign, but he was very candid that had he realized how expensive those events were going to be for Libya, that the gentleman he called the leader, Mr. Gaddafi, would have found other ways to be provocative. He would not have been in the business of murdering US citizens. For somebody like me, that's perfect. That's what we're trying to achieve. And if you're asking me, do I think that that kind of litigation, and it's built incrementally, it doesn't happen fast, could well serve the religious freedom world? I think it could. People do forget that the first case that I brought, and this goes all the way back to 1986, when I think I was 2.
Or 4, maybe.
Or 4, maybe.
Yeah.
Was a religious freedom case. It was a case that we brought against the Federal Republic of Germany for reparations for individuals who had been either United States civilians in Nazi concentration camps, that is, people who were U.S. passport holders who got trapped in German occupied Europe at the outbreak of the Second World War and who were not returned in the civilian prisoner exchange, or U.S. prisoners of war, most of these people were taken prisoner during the Battle of the Bulge, so we're talking about the last 6 months or so of the war, and who, because their dog tags had an H on it, went to Berga concentration camp instead of the normal POW facilities where U.S. servicemen went. That case ran about 9 years, but in the end, Germany agreed that it had an obligation to pay reparations, and our lead plaintiff became one of People magazine's 50 most interesting people of the year, and the case got much more television coverage in Germany than it did in the United States. There was a huge interest in the German public in that proceeding, and I do think it has a deterrent effect in the space that you folks are interested in and work in every day. Thank you.
Great. If we have time, we may have more follow-up questions for you. On our panel, our last member today is Brett Scharffs. Professor Scharffs is the Rex E. Lee Chair and Professor of Law. I want to just pause and say I had the privilege of working in a case with Rex Lee when I was about 7 years old and I was a young lawyer. Actually, I was in my 20s when I did that. But he is the director of the International Center for Law and Religion Studies at Brigham Young University Law School. His casebook, Law and Religion, National, International, and Comparative Perspectives, he co-authored with Cole Durham, has been translated into 11 languages and is the author with Elizabeth Clark of Religion and Law in the USA, as well as several books focusing on human dignity and religious freedom. In 2021, he became the chair of the International Human Rights section of the American Association of Law Schools. Very prestigious role. Professor Scharffs, the center you direct is the International Center for Law and Religion Studies at BYU. What's the significance of your work being at the intersection of law and religion? And are there examples of law reform efforts that you've been involved with that you would describe as a success story?
Thank you. I'd like to echo others in thanking the organizers, particularly Ambassador Brownback and Dr. Sweat, for convening this important forum. It's our honor and privilege to be a part of it. As a law professor, it's easy to wield a hammer and to imagine every problem as a nail that needs your attention. And we can overuse the law, I think. Not every problem needs a juricentric solution. On the other hand, when we find religious discrimination, when we find religious persecution, we almost always find bad laws accompanying those bad practices. What Tehmina discussed in India is a perfect example of laws mislabeled, called religious freedom laws, that are designed and intended to intimidate those who would exercise their religious freedom. And we need those laws to be changed. It's not going to solve every problem, but it's an important part of any solution to the problems. You ask about some success stories. The one that Congressman Wolf was discussing just a few minutes ago, the International Religious Freedom Act, passed virtually unanimously in the 1990s, late 1990s, along with the Religious Freedom Restoration Act in the United States, I think are very important examples. IRFA did something remarkable, and I'm not sure it was the centerpiece of the law, but it requires the State Department every year to issue a report analyzing the status of religious freedom in every country in the world. Now think about that. What does that mean as a practical matter? Now recall that the State Department, a secular institution, resisted the adoption of that law. It was more or less forced down their throats by Congress. And what it meant is that in every embassy in the world where there's a U.S. embassy, someone, usually the most junior political officer, had a job to do every year, and that was to report on what was happening in their country of service with respect to religious freedom. And so they started talking to religious leaders, and in particular to religious minorities. And they found out that there were a lot of problems. And what this meant is that 25 years later, there is a large cadre of State Department people who have gotten comfortable talking with religious leaders and have come to be sensitive to the problems of religious discrimination and religious persecution. Now, we've been focusing, and rightly so, on some of the most egregious violations of religious freedom in this gathering. But as a lawyer, the place where we see the most discrimination, the most mistreatment of religion, is in pretty unglamorous places like registration laws. Are you able to register your religious group under the law or not? This isn't an issue in the United States, but it's an issue in many other places, and it's a big issue in a surprisingly large number of places. Another is land use and zoning. We're not going to make any docuseries about this. It's not a very sexy or glamorous topic. But if you want to find religious discrimination in the United States or anywhere else, go to the zoning and planning meeting and see how different groups are treated there. And so, yes, law is downstream from culture. Yes, every problem is not a legal problem that needs a legal solution, but the intersection of law and religion gives us an opportunity to take very sensitive and very controversial issues, hopefully lower the temperature, lower the volume, and find practical solutions to very real problems. Just in the last week here in the United States, we saw two important Supreme Court cases decided which illustrate the importance of the law. One involved a program in Maine that discriminated against religious schools in their participation in funding programs. This is a very significant case that really changes the terrain for the participation of religious schools in the schooling tapestry of the United States. And then the other, of course, was the Washington high school football coach who was finally vindicated after a long struggle in his right to pray at midfield after a football game. So those are legal solutions to real problems. They're not permanent solutions, they're not complete solutions, but they're illustrations of how important the law is to the intersection of religion and our public life.
Well, thank you. I see that our time is nearly gone, so I will just conclude our panel with two observations flowing from your remarks. First of all, as I mentioned, I've been in India with Tehmina on two occasions, most recently in late April of this year. And we met with a group of people that we're representing, our team is representing in India, who have been victimized by these anti-conversion laws. One example was a young man who was praying for the health of a relative, and he was arrested for anti-conversion activities for praying out loud, not in anything that you would think is a public space, on a balcony of a relative. And he had been arrested and beaten by the police 6 days before I met with him. And so I saw the bruises, and sometimes we end up thinking of these things in abstractions. And they're not abstractions. They're real people that are really hurting and really suffering. The second thing, and I just want to celebrate the wide diversity of this audience, and it reminds me of, we had a mention of the Religious Freedom Restoration Act. I was on the executive committee of the lawyers who drafted and worked for the passage of the Religious Freedom Restoration Act, and I was actually the co-chairman of the drafting committee of RFRA. And I view that as one of the highlights of my 40-plus year career in law and politics. And it came because everybody stood together for one principle, and that is religious freedoms for everybody. And that's a principle that unfortunately is dwindling in support even here in the United States. And the greatest thing that we can do is to stand up for that principle, religious freedom is for everybody. If you think religious freedom, and I know this audience is, I'm preaching literally to the choir, but if anyone thinks that religious freedom is for people like me, then you don't understand religious freedom at all. You're just interested in a series of privileges. Religious freedom is when we stand for people that we disagree with completely on a matter of faith, matter of doctrine, matter of theology, and yet we say their freedom is important as mine. And so that's the commitment that this audience shares, and that's the commitment that I believe is important for us, not only here in the United States, but worldwide. God bless you. Thank you so much for being a part of this.